Hello and welcome. I'm Peter Afrasiabi. I'm a partner at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. I also teach at the University of California Irvine School of Law, where I teach advocacy and clinical Ninth Circuit appellate litigation to law students. Today's program is Implicit Bias. Me, you, and our judges too. What we're looking at today is the issue of implicit bias in the law, and this revolves around the new California State Bar CLE requirements that are also being adopted in various jurisdictions that have specific requirements for us to look at, train, educate, discuss, talk about implicit bias and how it may affect us and all the constituents of the legal system. But first I want to talk to you about what this is not about and what this program is about. And so this is what's important. This is not a negative program, and it's not accusatory. I'm not here to lecture you or tell you that you're biased or you're embracing certain isms or other isms or not. Instead, what this is a positive exploration, really, of the issues that sit beneath implicit bias. And those are really just our unconscious associations between various events or data that may lead us to have schemas or categorizations in our minds that draw connections between things. And so we're going to look at this through the prism of the required CLE standards without any charge or negativity. Instead, what we're actually going to do is figure out how we can learn about implicit bias to ultimately be better advocates and better lawyers. Because if we can unpackage those mental connections that we may be making that are unconscious or subconscious, that may or may not involve race or gender or other known isms, but they may involve all manner of things that aren't particularly nasty, evil. They can just be banal, in all manner of circumstances. But they can be really important to us as lawyers if we are making mistakes in terms of how we are, for example, evaluating the credibility of witnesses, we are picking juries and the like. And so ultimately what we will do today is look at implicit bias in the law through the prism of actual cases that lawyers have litigated, cases judges have decided, because this afflicts judges too, of course. And we will look at how we trigger implicit bias with word choices that we as lawyers or as judges in our legal writing and case development may make. And we will look at some judicial opinions and even examples in the patent realm, for example, of implicit bias at play in advocacy in the courts. And so ultimately, under the requirements, we will look at all the constituents of the system. The judges, the lawyers, the witnesses, and the jurors, and really the systemic nature of the system as a whole. And our goal? To be better advocates. We want to find actionable steps that we can take to recognize our implicit bias and to then ultimately make better decisions as lawyers for our clients, to be better lawyers. And let's start here, because this is common for everyone and it's not accusatory or negative at all, but it's important to understand what implicit bias is, and we can look at one form of implicit bias before we dive in, and that is confirmation bias. We all know it, and we know to be careful of it. So here's confirmation bias. This is when decision makers actively seek out and assign more weight to evidence that confirms their hypothesis, and they ignore or underweight evidence that could disconfirm their hypothesis. It creates a tendency to seek out information or to view things in a way that confirms what you already believe. Confirmation bias contributes to overconfidence in personal beliefs, even when faced with contrary evidence. Now, all of us, as lawyers at least, are hyper aware always of confirmation bias, which is to say, we all already know about one form of implicit bias already. Not only do we know about it, we all try to be very, very careful about it. It can be our Achilles heel. It can affect our perspective of things, such as what's the best route to take in litigation for the client? How good are our arguments? Are they really as strong as we think? How weak are the other side's arguments? Are we improperly discounting the strength of the other side so that we end up not taking optimal settlements and we end up trying cases we shouldn't try? In other words, all of us know we have to be careful and be constantly on vigilant alert for allowing confirmation bias to affect us, which happens all the time when we look at pieces of evidence and we say, oh, that helps my theory of the case, and we then believe we're doing the right thing, and we look at other evidence that may be countering our theory of the case and we discount it. So We also see this all the time in the context of expert and expert discovery, where we offensively look to see if the other side's experts are actually engaged in legitimate expert work or if they themselves have cherry-picked data for confirmation bias. And so this is a form of implicit bias that exists that we are all well aware of. But now let's talk on the third slide here we're looking at today, and that is implicit bias and the regulatory overview. I want to step back and just talk a little bit about what brought us all together today to share this 60-minute period talking about implicit bias. In 2020, the California legislature enacted California Business and Professions Code section 6070.5. And this is much like many of you who are not in California, but it's much like many other implicit bias ethics type standards in all of your jurisdictions. But this just happens to be the California one. And it required that the California minimum continuing legal education system be updated with requirements for lawyers that include, quote, training on implicit bias and the promotion of bias-reducing strategies to address how unintended biases regarding race, ethnicity, gender identity, sexual orientation, socioeconomic status, or other characteristics undermine confidence in the legal system. And in 2021, the California State Bar, at least, increased its MCLE hours requirements for implicit bias from 1 to 2 hours, so that there has to be 1 hour of those 2 specifically on the topic of implicit bias. Now, big picture, why are we suddenly having this conversation? Why are these changes? Where does this come from? I mean, the law has for quite a while actually talked and addressed at some level implicit bias. But as we all know, in the last few years, this has sort of become a mainstream topic of cultural conversation. And so we can watch this short 2.5-minute video just to see a big picture overview of implicit bias at a macro level in terms of where this is coming from and what's going on.
Implicit bias.
Implicit bias.
Implicit bias.
2016 was the year that implicit bias went somewhat mainstream.
Yeah, so when Hillary Clinton mentioned implicit bias in the debates, our phones started blowing up, all our friends started emailing us about it.
But what is implicit bias? Implicit biases are basically thought processes that happen without you even knowing it. Little mental shortcuts that hold judgments you might not agree with. And sometimes those shortcuts are based on race. First, some clarity. Saying someone has an implicit bias is different from calling someone a racist.
The word racist is a highly loaded term, right, here in American society. A lot of times, when people are using it, they're thinking of the kind of old-fashioned Ku Klux Klan style racist.
But implicit bias isn't anywhere near that, explicit.
Implicit bias is something that comes out of ordinary mental functioning, out of how the mind normally works.
We've all grown up in a culture with media images, news images, conversations we heard at home, our education. Think of that as a fog we've been breathing our whole life. We'd never even realized it, what we were taking in.
And that fog causes associations that lead to biases.
I somehow know that if you say peanut butter, I'm going to say jelly. That's an association that's been ingrained in me because throughout my life, peanut butter and jelly are together. And in many forms of media, there is an overrepresentation of black men and violent crime being paired together.
And because of that, I actually deep down inside have been taught that black men are violent and aggressive and not to be trusted, that they're criminals, that they're thugs.
With all those associations, I'm not trying to let us off the hook, but in some ways, none of us stood a chance.
Starting today, we'll post a video a day dealing with one challenge of understanding implicit bias and its relationship to race and exploring ways we might combat the problem. One more thing, if you're seeing this and thinking that it doesn't apply to you, well, you might be falling prey to the blind spot bias. That's a scientific name for a mental bias that allows you to see biases in others, but not in yourself. We're biased.
So there you had it. Let's look at the next slide at some definitions. We're going to talk about implicit and explicit bias, and all of us are familiar with explicit bias, but let's first get some definitions on the table so that we can walk through this program. Implicit bias looks at the idea that there are thought processes that occur without us knowing, and that these thought processes that are occurring in all of us end up creating associations between events or data that can lead to then biases in thinking and decision making. attitudes or stereotypes that impact our interpretation of events and people, our decision making, our behavior, and this occurs without even necessarily our express awareness of it. Some of these associations lead to negative, unfounded biases, of course. They can create racism, genderism, ageism, sexism, and the like. But some are just biases in our schemes of thinking that don't particularly carry charged weight. They just are connections and correlations that exist. But they're all there, and they all matter, and we need to know it so that we can ultimately be better advocates, because we want to unpackage, certainly if we're engaged in improper, explicit biases that would be prohibited by law. We want to be better, obviously, lawyers and people than that. But it also matters, I think, for us to unpackage as advocates what you may call banal biases may exist in our thinking that don't carry the kind of charged weight that we normally talk about when we're talking about bias. But they do affect us and the legal system, because if you remember on that slide a couple slides back, part of what we're looking at is not just race, ethnicity, gender, sexual orientation, socioeconomic status, but we're also looking at other characteristics that can ultimately undermine confidence in the legal system. And so if we are, as lawyers and advocates, making errors in our judgments and our advice to our clients, if judges are making errors in judgment in how they're deciding cases because of other characteristics too that maybe don't get as much weight, then we have a systemic problem in terms of we're not all delivering the best legal advocacy we can deliver. And that's what I want to really discuss and focus on today as we walk through this bias program. Now, explicit bias is overt racism, sexism, and other biases that have obviously played a major role in the legal space and in society, of course, for decades. And in the legal space, we are all familiar with it from the anti-discrimination laws, the equal protection challenges, and really the entire history of our country and our constitutional standards. And there we're familiar with it as lawyers. It's a comfortable playing field for us as lawyers. And as you can see on the next slide, we can pick up a couple of cases that have dealt with explicit bias. And the reason I want to talk briefly about explicit bias is it helps us frame the understanding of what we're getting to as we start unpackaging more what implicit bias is. So let's just take a look at explicit bias, and we'll go from Batson versus Kentucky in 1986 all the way to Pena-Rodriguez versus Colorado in 2017, two Supreme Court cases that are dealing with explicit bias and juries. And so Batson was the famous Supreme Court case that addressed the question of whether a prosecutor's use of peremptory challenges to exclude 4 black jurors violated the right to a fair jury trial. And what the Supreme Court held is that racial discrimination in the selection of jurors not only deprives the accused of important rights during a trial, but it's also devastating to the community at large because it undermines public confidence in the fairness of our system of justice. And so it stands obviously and importantly for the proposition that there cannot be this kind of explicit bias in picking juries. In Pena-Rodriguez, this is a 2017 case. You can fast forward a generation plus. What the Supreme Court held is that for the inquiry to proceed, there must be a showing that one or more jurors made statements exhibiting overt racial bias that cast serious doubt on the fairness and impartiality of the jury's deliberations and resulting verdict. And so all of these cases thus far have required a showing of explicit bias to trigger these constitutional concerns for a fair jury trial. The Supreme Court, at least as of yet, hasn't extended this to implicit bias, but as you'll see today, there's a lot of jury instruction and jury discussion that's occurring in terms of trying to make sure we ferret out implicit bias too. So now let's unpackage implicit bias in more detail. And here's a good 6-minute video for you to watch, and I'll be back in, after the 6 minutes. Really, this is from the ABA, and it's a fantastic overview, ultimately, of what we are unpackaging when we talk about implicit bias here.
You can conceptualize mental processes as a big iceberg, and you can conceptualize the part of the iceberg that sits above the waterline as being just the very, very tip. That's a small amount. And that very tip of the iceberg are the cognitive processes or mental processes that we're aware of. And all the rest underneath the waterline is all the automatic processes that happen behind the scenes that help you to learn and to interact with your environment. And when we're talking about implicit attitudes, we're talking about things that you've learned through interacting with your environment that sit below the level of the surface. You may not even be aware of the attitudes that you have that have been built up over time based on your interactions with others.
We like to think that we have full access to what's going on in our bodies and our brains, but the truth is that our brains are very, very complicated machines. They do lots of things, lots of work, lots of perception, lots of recording, lots of memory, lots of recall, lots of cognitions that are completely underneath the level of conscious self-awareness. And given that fact, people may not be able to accurately report the cognitions that are going on in their heads. Our brains are in some ways like neural networks. How do we learn? We learn things all the time. Every second that we're alive, we're constantly being exposed to different kinds of images, experiences, sometimes with real people that you interact with, but more often with vicarious experiences that are told to us through stories, through the media, through television, right? And by constant bombardment of these things through personal experiences and everything that culture teaches us, it's as if our brain automatically picks up on the associations that we see. So even if we individually might not put white over black, even if we don't individually think that math should be more associated with men than women, it might turn out that our brains have picked up just those associations.
Advances in technology have allowed scientists to peer inside the brain while it is thinking. The brain is an exceedingly complex set of systems and subsystems interacting with one another. Yet there are parts of the brain that neuroscientists have been able to isolate and study in order to understand how they function in the midst of the complexity.
We're looking at an indicator of blood flow, and this tells us something about the neural activity going on in the brain in a continuous dynamic manner. And so we can use that now to look at how different parts of the brain show more neural activity when you're engaging in different kinds of tasks.
These implicit attitudes or societal effects on our mind is like the operating system of a computer running in the background, where the conscious thoughts are the applications. It's like, Word running in the foreground or internet running in the foreground, but in the background there's stuff going on that we're usually not conscious of.
The most popular instrument, the one that's best known and has been most widely studied, is something called the implicit association test, created by Tony Greenwald.
It's a test that measures association strengths. Now, that doesn't sound like it's of great importance, but it turns out that association strengths are at the heart of attitudes and stereotypes. And as we've done research using the IAT, it's turned out that it's revealed things that we didn't know, because it measures these associations that people are not even aware that they have.
The IAT has been taken by over 2.5 million people online. Here's how the race IAT works. 2 categories appear on either side of the screen, like good, bad, African American, Caucasian. Then a picture or a word appears in the center of the screen. You must match the picture or word in the center with the proper category. For half of the test, you may be instructed to match African American faces with good and Caucasian faces with bad. For the second half of the test, the matching instructions will switch, and you will be asked to match the faces with the other category. The test records how quickly you pair those 2 categories and concepts, and how many mistakes you make. You set the pace, and the computer compares your speed and accuracy of pairing in part 1 and part 2 of the test. If you make more mistakes or take longer to sort one race with good, then psychologists interpret this to mean that you have an implicit bias against that group.
A lot of the IAT results that we observe are shared widely in the population. So we have an IAT that associates women more with family, men more with career. Every group we look at shows that. You might think women don't show it as much as men. Actually, they show it slightly more.
For me, the IAT was kind of and I think other people have described it similarly, sort of an aha moment. I've been very active in the civil rights movement before I became a judge. I've always been very interested in issues of racial equality. And I think I scored as having moderate, at least a moderate level of implicit bias. And so I was initially quite defensive about it and tried to explain it away in terms of the technology that was involved and, the context in which I took it, et cetera. But it did, but as I reflected on it, it did begin to make more and more sense to me in terms of explaining some of my own ambiguous feelings about the role that race played in my life.
Here we can look at, after that video, this professor schema. And here's a way of looking at bias and implicit bias in terms of just some common social categorizations that we may make in terms of schemas that we make in our minds. And so here we've picked students and professors. And so when we talk about students and professors, let's talk from the student's perspective first. And this is on the left column, you see students regarding professors. What do students assume in terms of their implicit assumptions? They assume that professors know their subjects, that they prepare for and attend class, that they have office hours, that they give assignments, they grade them, they generally grade them fairly. And so these are the types of schemas that students put in their minds about professors. And then they rely on those in order to predict and explain a professor's behavior, and also to fill in gaps if the professor's actions are somehow ambiguous or inconsistent with the behavior. And what's also important here is that those implicit assumptions, those implicit biases, these schemas that exist, can eventually change over time based on a particular individual's performance, but where they start are at high levels of generality. And so we can think of it in this sense. When we all showed up as students in the professor's class on the first day, we don't think of that professor individually as the person that he or she is. We thought of them as just generic professors, and so that's where our schema comes from. And we have then this implicit general view of likely professorial attributes. And so our expectations then flow from that implicit schema we've created. And our social cognitions then develop around it. And then from that implicit schema, we tend to find explanations for contradictory or alternative behavior that may fit with our schema. So for example, we generally think professors attend class. And so if a professor's late one day, what's the instinct of the student? The student's instinct is, oh, something happened, an emergency arose, because the professor's always there on time. Now, if this professor is consistently late, then that implicit assumption about, the professor just attends class on time will shift over time, and maybe students decide it's kind of a lousy professor I've got here, or they're absentee and they're kind of haphazard or something. That's an example then of how these schemas predispose us to expect certain outcomes or expectancies, and then we evaluate others in a way that may confirm them. And of course, those may change over time depending upon the amount of challenge we get to it. But that kind of implicit bias that exists between the data sets and the relationship between students and professors is exactly one example of what we obviously as lawyers have to confront and address in all manners of what we do. So now let's peel back implicit bias a little bit. And on the next slide here, you can see we're talking about implicit bias peeled back. And it's really the lens through which we view the world. And this is, to a large extent, one way of defining at a high level of generality, really what implicit bias is. It's just a lens that we all have for a variety of reasons by which we just see the world and interpret data and information and make correlations and connections. And these schemas or implicit biases that exist end up creating preferences for groups that can be positive or negative. And these are groups that cut across all manner of definitions, race, religion, orientations, football, tribes, you name it. They often operate outside our awareness. They're based on stereotypes and attitudes that we hold. And these tend to develop early in life. Psychology and psychological evidence has proven. And they tend to strengthen over time. And of course, one can just look at these bullet points and know, watching this as a lawyer, that this is incredibly important for us to know and think about as lawyers to make sure that we can ultimately give the best advice to our clients so that we are not, as a function of our own implicit biases, damaging our clients' cases. So what you can do, as you saw in those videos, is to really get to the root of this is you can take the implicit association test, and it's a computerized test that really uses 2 keys. It's fascinating to take it. I highly recommend it. I did it, and I did it, as you see, I put up a picture of President Reagan and President Biden, and I did the implicit association test in the political realm, but there's multiple different tests you can take. Race, religion, gender, all manner of things. I picked politics. And basically the way the test works to develop and identify the implicit biases we have is you have used 2 keys on a computer, and there are 2 social and 2 evaluative categories. And so I did the one, for example, with President Biden, President Reagan, and good and bad. And so basically what happens in the test is you are told, you're given a picture of President Reagan and a picture of President Biden, and you're told that you'll be given good words and bad words. And what flashes up on the screen, and you're told use the A key for good and Reagan on test 1, and then the D key for bad and Biden on the other. And so pictures and words pop up, and then you just hit if you're on the module where it's good and Reagan. Every time you see Reagan, you hit that key. Every time you see a word that's associated with good, you hit that key, and the same for Biden. And then it switches it where it may be Reagan and bad words, you hit this key, and Biden and good words, you hit this key. And then it's just the words or just the pictures of the presidents. And so what happens then is the speed with which you're associating these categories on these things where there's only one right answer, right? I mean, if the word is horrendous and you accidentally hit the good key, it'll tell you you made a mistake. And I made several mistakes because it's picking up how fast you're associating the connections. And so what happens then is closely associated categories are easier and quicker to sort together. And so what's being tracked here are faster reaction times to pick up your implicit connections between good and bad, between President Reagan and President Biden, what you see as being good and bad. And so it's incredibly fascinating, and it was incredibly enlightening for me. I mean, honestly, I was amazed at sort of when the test results came out, it sort of indicated that I had a slight implicit bias in favor of one, not the other. I'm not going to tell you who. That's why you see my tie. It's red and blue. No politics here. But nonetheless, I think it's very, very much worth doing to unpackage and see in a variety of different areas the way we can actually implicitly draw connections between these social and evaluative categories. It's really important for us to know. And there's a bunch of places you can take it. It's private. You have on the website here one of them, and that's at the harvard.edu website. Now, let's talk a little bit about this implicit bias, California Business Profession Code, Section 6070, the constituents, and the constituents that we have to be focused on for purposes of implicit bias. And there are 3 major categories. We have the third parties that interact with our legal system, and those are the witnesses and jurors principally that we're looking at. We have judges and we have lawyers. And at a high level, what we know is that studies have shown that eyewitness testimony, particularly on racial identification issues, can indeed have reliability issues. And this is significant for third-party witnesses who are testifying in court and for jurors who are interpreting that witness testimony. And so that's one example where implicit bias becomes very important to unpackage. And we're going to go through all of these 3 constituents in detail. This is just an overview for you, so stay tuned. But that's just the first bullet point. The second one, we want to talk about judges. And we have studies that show that some judges will rely more on intuition, perhaps, than deliberative judging on issues being decided. And these are some sites that you can go read, some very detailed articles with underlying data on this in terms of this intuition versus a slightly different deliberative process that we may expect, perhaps realistically or unrealistically. But nonetheless, if we have judges relying on intuition, then we know that those schemas and those implicit biases are bubbling up to the surface in terms of figuring out an outcome of a case. And of course, for us lawyers, we have to decide all manner of things. If we're prosecutors, we have to decide, who do we prosecute? Who do we plea out? Why are we prosecuting this person and not that person? Why are we giving this person a plea deal but not that person? These are significant decisions. And the why that may animate that decision, if it's triggered by implicit biases, we want to know what they are and make sure they're not illegitimate ones. We as lawyers have to decide who we're going to keep on juries or who we're going to try to exclude. And Obviously the Constitution speaks to it when it comes to like the Batson case we looked at, excluding people on improper grounds, such as race, for example. But there may be all manner of grounds that aren't constitutionally prohibited to exclude jurors. But we may still exclude jurors on those grounds because of our implicit biases. And we want to figure out that, are we doing it because of something legitimate and rational, or is it an implicit bias that may be wrong? For example, maybe someone thinks that anyone with blue eyes isn't trustable, for example, which wouldn't trigger kind of race discrimination. But are you actually helping your client if you bounce all blue-eyed jurors? Maybe you are, maybe you're not. But if that's why you're doing it, you should understand kind of what's really going on and animating that decision, because you don't want to damage your client. So that's an example of it. Another one that we as lawyers address are decisions on who are credible witnesses, based on these types of issues too. So let's talk now, we're going to go through all three of these categories: witnesses, judges, lawyers. Let's start with the witness-juror example and look at some implicit bias from the witness perspective. And so this is the cross-racial identification issue we spoke about. And so when cross-racial identifications are made, these can trigger issues. And so what is cross-racial identification? It's when the witness and the defendant being identified are of different racial backgrounds. And so when this happens, questions arise in the legal system about the fact that there are risks of erroneous convictions because of the data that's just shown cross-racial identifications lead to higher error rates than in other areas, for example. And so what's happened here then is that judges are being asked more and more to decide whether jury instructions have to be given or whether experts should be brought in to delve into the issue, to figure out if implicit bias could be at work in terms of the validity of that identification being made in a cross-racial identification situation. This actually has led in 2008 to the ABA approving a resolution that urges courts to recognize that in particular cases, cross-racial identification may increase the risk of an erroneous conviction. An expert testimony should be omitted to discuss empirical studies in the area and jury instructions given when appropriate. Now, it turns out this hasn't just come from the ABA. The Supreme Court of New Jersey has touched upon this too. And here's our witness example continued. And this is State versus Cromedy, 158 New Jersey 112 in 1999. And here we have a situation where the New Jersey Supreme Court ultimately held that the criminal practice and model jury committees for the state of New Jersey develop a cross-racial jury instruction in accordance with that court's opinion in that case, that held that, quote, this cross-racial instruction should be given only when identification is a critical issue in the case and an eyewitness's cross-racial identification is not corroborated by other evidence giving it independent reliability. So now let's shift from the witness example, we're staying in the third-party realm, to a juror example. And this is looking at implicit bias in the context of juror questioning and what the law looks at, demands, and expects in this situation when we have juror questioning and a request to do voir dire on implicit bias. And so this is an Eighth Circuit case called United States versus Young. It's reported at 6 F 4th 804. It's from the Eighth Circuit in 2021. And here's what happened. Near the end of voir dire, the defendant Young's attorney objected and said to the court, I want to note for the record that I'd like to voir dire on race. And it seems there's some kind of implicit bias that the jurors here might have about the defendant's race. So what happened? The judge asked about express bias, but never mentioned implicit bias. Didn't find any express bias, everything was fine, moved along, impaneled the jury. Trial unfolds, the defendant is convicted. Now on appeal, Young argued that the failure to inquire on implicit bias required reversible error. The Eighth Circuit should reverse. Now what the majority held is they sidestepped it in a sense because they said, or maybe they didn't, what they said is race was not inextricably intertwined, so there was no need to delve into it. So in other words, we will delve into it perhaps if race is truly inextricably intertwined, but if it's not, we don't necessarily have to unpackage implicit bias because we're not looking for non-race implicit bias. Now, we have a dissent concurrence here that's important, because it's calling out the need to really push the courts to peel back this onion of bias to get past express and into the realm of implicit. Here's what the judge said. I nevertheless suggest that more can be done to diminish any influence implicit bias might have on a jury's deliberations. For example, a district court might take meaningful steps to educate the venire and the impaneled jury about implicit bias. Indeed, some courts show videos to juries and use special instructions in every case to highlight and combat the problems presented by unconscious bias. And it's really fascinating. And so what this dissent did is say that, look, this unconscious implicit bias issue is massive, it's significant, it goes beyond trying to ferret out race or gender type discrimination. We need to ferret it out in all thinking to make sure that we have truly the fairest trials possible. And what you see there is a citation to a video that's used in the United States District Court for the Western District of Washington on unconscious bias. And don't worry, you'll be watching a snippet of that video in a little while. But there's the link, because it's a fantastic video that's used in that court to really help all potential jurors make sure that they question, challenge, and understand what implicit biases may be in their thinking. Now, from here, we're going to shift to an example of a judge. And this is, we're going to go back in time to the 1970s. And we're going to take the case of Rusk versus the state of Maryland, reported at 43 Maryland Appellate Courts, 476, 1979. And we have a majority and a dissent here. And this is a good case at looking at the impact on people really accessing the legal system, here a victim, and implicit bias in decision-making and the writing of judges. And this is important to look at because it's a chance for us to see how implicit bias takes root in the legal writing, not just of judges and opinions, but obviously in the legal writing that we present to courts as we advocate for our clients. And so what I've done here is chart the majority and the dissent in this case. And I've highlighted some of the language in pink and some in red, so you can compare two different ways of writing the facts about a common fact pattern. And so this is just a small snippet of the decision, really just talking about the facts. And so what we can see is on the left, we have the majority who are discussing what happened in this case. And ultimately, it's a rape case against the defendant Rusk, who had raped the victim. And so the majority says, in describing the facts about what happened to this rape victim, the prosecutrix was a 21-year-old mother of a 2-year-old son. She was separated from her husband but not yet divorced. Leaving her son with her mother, she attended a reunion, after which she and a friend, Terry, went bar hopping. So just that framing, we see a vision of the world that is picked up on by a series of implicit biases you can unpackage in that language. Now if we shift to the dissent says the victim, and I'll give her a name, Pat, attended a reunion. She had arranged to meet her friend there. The reunion was over at 9, and the friend asked her to accompany her to Fells Point. That's the bar. And then you go a little bit further down. She agreed to go, but first called her mother, who was babysitting, to tell her that she was going with Terry to Fells Point and that she would be home late. So that is two different ways of framing and describing what is going on. One, we have a prosecutrix who went bar hopping, and this is the victim of rape. And in the other, we have a victim who called her mother to ask her to babysit the child. And those are two different ways of framing and describing what had happened. And they're built upon the implicit biases. And so we have some other language in red too that you can see that equally looks at two different ways. Now this case, of course, not only is it an example of implicit bias, it's probably an example of explicit bias. And the good news for those of you watching it is the inappropriate nature of how the majority framed this case failed, because the Supreme Court of Maryland reversed and agreed ultimately with the dissent that if you read the case, it's a very impassioned dissent about the improper framing of the facts. But this is a good example of, for us at least, looking at implicit bias to recognize and understand that the writing, not only of us as lawyers, but of judges, when framed through and picked up on underlying biases and these categorizations that are occurring in these schemas, can end up impacting the people accessing the system. Here you have one who's a victim of rape, who's being written about in a way that's a function of those biases. And so you see on the next slide here, the point that I'm making really is that word choice is really important. We as lawyers are writers, we're advocates, and we write a lot. And that word choice can be a signal, and it's something we have to be attuned to. Indeed, it's something we're always attuned to. But what we should be attuned to, because we are always, as lawyers, writing to frame issues. It's part of our advocacy. You can go watch a series of our programs on advocacy. I've done 3 or 4 of them on the same platform you're on, built around advocacy, including oral but also written advocacy. But as we engage in written advocacy, we are often thinking about how we can trip into tropes or narratives or ideas that we think are going to be appealing to the judge. And in that, we are employing often these implicit biases. And so we want to be aware of them, and we want to make sure we're always unpackaging them and knowing that if we're doing it right or wrong. Now, here's another example from 2022. And this is the case of Simmons versus Romo. And here you can see, again, colored language, looking between a majority and a dissent at the same basic facts that are put before them in a case. And basically, it's a case of a prison fight and between one prisoner and another. And the prison guard shoots the prisoner, who's the plaintiff Simmons in this case, who then sues the guard for having shot him. And the guard is Arnett, and the prisoner was Simmons, and so Simmons is shot by Garnett. And so some of the simplest framing of the facts we see here in the beginning. We have the majority saying that the perpetrator, Murillo, walked past Simmons and then suddenly turned around, struck him in the head right above his left ear. Murillo continued to hit Simmons, who says he did not fight back. So that's one way of framing a fact, right? Murillo is punching him, and Simmons says he did not fight back. Now, the dissent says that actually the facts look a little bit different. Based from the attack, Simmons made no attempt to punch back. And so we can see right there, there's a big difference in terms of what implicit bias are we employing. Are we saying that someone was dazed and therefore unable to punch back? Or are we saying that someone was being hit and claims he didn't fight back, which implies subtly that maybe he was, maybe he wasn't, it's in the eye of the beholder, you pick. And those are 2 different things when you're talking about a question of culpability and whether someone's at fault. You can see in the green, if you go down a little bit, there's another example. Arnett says he kept ordering the 2 inmates to stop fighting without any success. And the dissent says Simmons never heard any orders before he was shot. And so again, we have 2 different implicit biases that you can see animating sort of the framing of the facts. In one, we are focused on how the guard is telling people stop fighting unsuccessfully, which implies they were ignoring him or not listening, including the victim. And in the other one, we have the victim saying the facts showed that I never heard him. So I wasn't, failing or ignoring or willfully being disobedient. I just never heard it. And so this different way of framing facts matters. Now, it turns out this case was a summary judgment case, so it's particularly important for another reason, which is whose version should you be looking at. But what we can see is those are 2, it turned out because it was summary judgment, we have the majority and the dissent, but it could equally be, if it went to trial, what the majority is saying is what the defendant would be saying, the prison guard, and what the dissent is saying here in this example is what the plaintiff Simmons would be saying in terms of the facts. And we frame facts differently all the time, built upon these implicit biases. And so this is a good example of seeing one from judges in their legal writing at summary judgment in terms of what's animating them. Now, it turns out this implicit bias, it's not new to the law in some sense. I mean, obviously, we've been talking about it in different ways for a long time. But here's another area in which it's animated the law in terms of areas outside of Batson. And this can be in the context of judicial disqualifications. And so I've got cited here the statutes and codes for you on judicial disqualification standards. But fundamentally, we have a rule in our disqualification jurisprudence that's built around this question. Would a reasonable outside person, a non-lawyer that is, just an outside observer, challenge the judge's impartiality here? And the major rule that then distills from all these statutes and rules and case law and standards is that we disqualify for the appearance of partiality as viewed from the perspective of a reasonable, non-judge, thoughtful person. And so what this means is that the public perception, policy, and outward facts if they could be construed as bias, this enables us to not do a subjective heart and mind inquiry. And so what we do is we strain to assess whether anyone looking at this would think that the judge could harbor a concern in some way that wouldn't be fair and proper. And so what we're ultimately doing really at root is we're long looking in the judicial disqualification context to assess whether there is implicit bias and whether it's been triggered by some sort of connection between a judge's behavior and others' perceptions of extreme fairness. And so at some level, these disqualification inquiries are like the other side of the implicit bias coin, and that's what we're constantly trying to ferret out to ensure a fair system. And so you can look here on the next slide. Here's an example of this in the context of a judge's comment on public issues. And this is the case of United States versus Cooley, reported at 1F 3rd 985 from the 10th Circuit in 1993. And the basic facts are that the judge appeared on television, in the context of just being, a pundit or a television spokesperson or a talking head on a news program and whatnot. And it was in the context of abortion protests going on. And the judge is then interviewed or asked a question on this television program and basically says that the protests were illegal. And then it turned out later on there are charges that are brought, cases being brought, and it lands happenstance before the same judge. A disqualification motion is brought and the judge refuses to disqualify. This then goes up to the 10th Circuit, and here's what the 10th Circuit held. Together, these messages unmistakably conveyed an uncommon interest and degree of personal involvement in the subject matter. It was an unusual thing for a judge to do, and it unavoidably created the appearance that the judge had become an active participant in bringing law and order to bear on the protesters, rather than remaining as a detached adjudicator. So there was no finding, actually, of express bias. Ultimately, this ruling hinged on the idea of implicit bias. It's just, there's an unavoidable perception in the public that you couldn't do your job as a judge figuring out whether a case involving someone involved in an abortion protest, whether that person followed or didn't follow the law in the subsequent prosecution, and your own professed public beliefs about it that you gave there. And so it's a perfect example, really, of how the law has experience dealing with implicit bias. It's around us all the time. And so it's nice to see and be aware, because we then know that we are armed with the tools in the judicial system, all of us, to really work on implicit bias, and we've been doing it in some contexts for a long time. Now, here's an example, and you're going to watch a few minutes from this segment, and this is really a fantastic example of judges on the good side of the line. I've given you a few examples, perhaps, of judges falling on either side of the line in terms of that old Maryland case, the more recent Simmons Ninth Circuit case, and then that judicial disqualification case. Perhaps we could, I don't want to talk about it in terms of good and bad judging, but in any event, here we have an example of something that's particularly positive, really, from judges, but also it's the systemic constituent of ensuring systemic protection for parties to a case and for jurors in terms of making sure we have the fairest of jury trials. So watch this short video here, and this comes from the Western District of Washington, and the video you're about to watch is accompanied by the following quote on the Western District of Washington's website. The video and jury instructions on this page were created by a committee of judges and attorneys and will be presented to jurors in every case with the intent of highlighting and combating the problems presented by unconscious bias. So here you go.
Thank you for being here. My name is John C. Kuhnauer, United States District Judge. As you have already heard, it is the court's goal in every jury trial to find jurors who will decide the case before them without prejudice or bias, because under our Constitution, everyone deserves a fair trial. So today I'd like to talk to you about what exactly bias is and why we should all keep improper biases out of the courtroom. Biases are prejudices in favor or against a thing, person, or group compared with another. Basically, bias equals prejudging in a positive way or a negative way. It's been proven that most biases happen at an unconscious level. In fact, researchers have found that unconscious bias is a part of how we all think and process information. It's important as jurors to be aware that unconscious bias exists. Once you understand what it is, we'll explore what you can do to address the effects of unconscious bias while serving on a jury, so that you can be sure you are making objective decisions and treating everyone fairly.
Earlier in this video, we all saw the judge. Truth is, each of us made instantaneous decisions or prejudgments about what type of person he is, even though we don't know him or have any additional information about him. Perhaps you instinctively felt that he was smart, impartial, patient, open-minded, or in charge. Or you may have concluded that he was all-powerful, tough, or scary. And when you first view this biker, you may instinctively feel he is either an adventurous free spirit or maybe a rebel who's tough, abrasive, or even dangerous. Through unconscious bias, our minds make quick decisions we are not aware of so that we can feel comfortable, safe, and confident. The fact is, we cannot process all the information we receive. So without knowing it, our minds create mental shortcuts and use our past experiences to help us make quick and efficient decisions. Take a look at this list of colors. Try and name the colors as quickly as possible while ignoring the words. Now, do the same thing with this list. Name the colors, not the words. While it may take a little longer to identify the colors in the second list because we aren't relying on color-coded shortcuts, taking the extra time to take in and process more information is worth it because more data helps us make more accurate decisions.
In fact, jurors have told us that once they were made aware of unconscious bias, they were able to check in with themselves during the trial and evaluate their decision-making process. Would they come to the same conclusion if the person on trial or the witness were someone of a different age or race or gender? This kind of conscious evaluation of our decision-making can help us avoid mistakes based on unconscious bias. Only after evaluation did the jurors feel confident they were judging the person on trial, the witness, or the lawyer fairly.
Now we're going to talk about some lawyer examples of implicit bias. And we can start with the big picture issues in terms of what we as lawyers do when it comes to thinking about this issue of implicit bias. And so we and others, it's not just lawyers, but we may judge credibility on things like, are people maintaining eyesight? Are they looking at us in the eyes? If they're looking it away, we may think they're being shifty and they're lying. But it turns out many cultures can find it disrespectful actually to maintain eye contact in that way. And so if we bring that implicit bias to bear on how we're picking, for example, a jury, we may find ourselves bouncing all sorts of people from a jury who may be very good for our case because of that implicit bias. And so we want to sort of understand the biases we're bringing to the table because they can genuinely affect whether we're actually doing the best job for our client or not. We also make the same judgments about all manner of things like race, religion, religious people, how they may be operating. We have judgments about potential clients even, and even taking the case could turn on implicit biases about the nature of who the potential client is. And if we, for example, if we do contingency intellectual property work like at my law firm, or if you happen to do contingency work for accident victims and you make judgments about those potential clients based on implicit biases, and then you end up not taking the case for some reason that may turn out not to be a good reason, in some sense, this is sort of an example of systemic implicit bias. We're denying access even to the judicial system because of our decisions that may or may not legitimately even have a good basis. We also do the same thing when it comes to implicit judgments about witness demeanor being tied to truth and credibility. And of course, there's the explicit ones when it comes to race, religion, socioeconomic status, and that type of stuff. What I also want to talk to you then is a good example of a lawyer example of witness interviews when we're interviewing witnesses, and ultimately what is an implicit bias situation that led to a motion for terminating sanctions against the plaintiff's lawyers in an employment discrimination case. And this is Goswami versus DePaul University. It's reported at 8 F sub 3rd 1004, coming out of the Northern District of Illinois in 2014. Here are the facts. The plaintiff was denied tenure, sues for race discrimination, and in the context of the case, the plaintiff's lawyers interview one of the defendant's faculty voters, and this is the witness. And this faculty member had favored giving plaintiff tenure and saw the denial of tenure as being race-based. And so the lawyers, during the case, went out and did an ex parte interview of the employee of the defendant, and in the context of that, showed this witness all sorts of emails that had been gathered in discovery from other people at the university who were talking negatively about the witness. And so when the defendant learned, they sought sanctions on a variety of grounds. And part of what they focused on was this idea that what was going on was an obvious ploy to stoke the witness, that's Dr. Larrabee, the witness's animosity towards the university department on the eve of her deposition. And what they were complaining was that by showing these emails of other folks at the university who had maybe spoken negatively about the witness, you were trying to trigger and solidify this underlying implicit bias that would kind of exist and push this witness into being hostile and negative and whatnot towards the university. So they bring the motion, and ultimately the district court denied terminating sanctions. That's a pretty extreme remedy, obviously, that we all know as litigators to ask for. But I permitted cross-examination on the bias issue because the witness's perceptions, as the judge noted, may have actually been part of her own confirmation bias. Dr. Larrabee made her views about those who voted against tenure luminously clear. Those who disagreed with her assessment of things were racially motivated. The notion that there could be a reasonable difference of opinion over plaintiff's qualifications was for Dr. Larrabee unthinkable. And so, perhaps because of the express bias of the witness that was so resolutely held, the lawyers didn't end up being bounced on full terminating sanctions for their conduct of trying to foster an implicit bias type situation because, in other words, it was harmless. She was already there as a witness. Now, that said, the district court was unhappy. And so the district court noted that the lawyer's behavior was stoking this implicit kind of bias and pushing to formalize and solidify those already existing confirmation biases built around race too. And actually, as a result, sanctioned the defendants for the costs of the whole thing. While the insults did not approach those of the Earl of Kent and King Lear, under a realistic appraisal of psychological tendencies and human weakness, it is idle to say that plaintiffs' experienced and skillful counsel did not know that the derisive emails contained the kind of personal insults that are not easily laughed off and brushed aside. Sanctions followed. So it's a very, very good example of where we as lawyers, when we're engaging in third-party witness interviews, we need to be careful about what kind of stoking we may be doing of biases that may lead to these situations. Here's another example coming from the patent law context. And this is a good example in terms of we can be thinking about systemic bias, which obviously is part of the mandate of the CLE for us to talk about. And here we can see some data. In 2016, 21% of patents had a female inventor, and only 12% of all patent inventors were women. It's a situation where patent examiners have wide discretion to grant patents. And as it turns out, data you can look at, and we have the sites here, shows that female inventor patent allowance rates are 5% less than male inventor allowance rates. And female inventors receive more office actions than male inventors. Office actions are patent examiners saying you have a problem, you need to answer this question, basically. And in a 500,000 implicit bias survey pool, data shows that 70% of people associate men with science and women with arts. This is the type of result that's been repeated everywhere in studies. The National Academy of Science experiment repeated it. And so what we have here then is a systemic example of implicit bias apparently present in our patent examiners, right? These are sort of people sitting behind the scenes deciding patents. This one's important, and it's built around gender and underlying biases built around the idea that men are more associated with science, perhaps women are more associated with the arts, and so that when women show up as patent inventors on patents, they are more likely to be rejected than men. And this is a very, very significant then example for us to be seeing in the literature of where implicit biases can have profound effects that need to be looked at, assessed, analyzed, and here discussed. So our final slide is conclusions, and this is our mandate. We are mandated to have a discussion about the actionable steps that we can take to recognize and address implicit bias. The first thing, be aware of it. Think yourself about your implicit unconscious biases. Question yourself, question snap judgments. That's good judgment, right? We all know that as litigators and as lawyers counseling people on the transactional side. Question yourself, look in the rearview mirror, be cautious about snap judgments. And this is a good way of unpackaging implicit bias. You can also take the IET test if you want to delve deeper. And as I told you about the test, I took it. I think it's well worth taking. It's fun and interesting, and it really lets you, I think, unpackage where you may have implicit biases so that they don't damage your lawyering. The areas that we should be focused on, too, are areas where there's massive discretion in the law, because wherever there's massive discretion in the law, there are ripe potentialities for implicit bias. And so this is discretionary decisions by judges and juries and patent examiners and other administrative officials. Prosecutorial discretion is a massive area. And of course, on the business side of what we do as lawyers, the legal hiring we do. Anywhere that vests lots of discretion has the potential for implicit bias to disturb and create improper outcomes. Other things that we can all do as lawyers is we can write about it, we can hold programs on it, we can seek jury instructions on it in your trials, like that fantastic jury instruction we watched from the Western District of Washington. You can send letters to the Patent and Trademark Office to ask them to train examiners on it. I mean, there's all manner of ways in which we as lawyers can reach out to start advancing this question of implicit bias to deal with it within the law. And ultimately, those are some macro things. At a very micro level, we can pay attention to the smallest of things, such as the word choice in our legal writing. And we can pay attention to whether we are using implicit biases in a way that is okay to advance, perhaps, and if we're using them in a way that's improper. So I thank you for watching this implicit bias program. I hope it's educated you and informed you and entertained you even at some level about this issue that's of paramount importance to the law, but we've been able to look at this issue in a non-accusatory, non-negative way and really frame it through the prism of how you and I and all of us can be better advocates and better lawyers to deliver better justice to our clients in the system. Thank you.